everyone. My name is Holly Morganelli. I'm the Global Learning Librarian, and I'm here in place of Eric Feldman, who usually moderates the Tuesday Times Roundtable. And I'm here as a dual Tuesday Times Roundtable and a WorldView Series, which is my Global Learning Library speaker series, which is a little bit of a copy off of Eric's Tuesday Times Roundtable, to be honest. So we decided to combine them for this one. And here today we have a very interesting presentation. I'd like to introduce Brett Spiegel. He is here to discuss research biases in when is a fact a fact. He's an international mass tort lawyer, and he worked for the U.S. Department of Justice and worked on the litigation against the big tobacco case of the U.S. versus Philip Morris. He did similar cases in us working in Australia, and he's going to talk to you a little bit about this interesting subject. So welcome, Brett. Thank you for coming.
Hello, thank you all. It's a pleasure to be here today. Thank you to Florida International University. Thank you to the New York Times. Doing this sort of presentation is a first for me, so I put together a bit of a presentation, but I also want it to be a back and forth. So if anyone wants to interject at any time with a question, raise your hand. Happy to have it be more of an informal conversation than a presentation as much as possible. So without further ado, I am a lawyer, which is not exactly the most respected and beloved profession in the United States. And to make matters worse, I am a plaintiff lawyer, which is extra bad in the minds of many. And part of what I'm here today to do, in addition to talking about the way we view facts in modern society, is also perhaps to try to convince a few of you that there may be some redeeming qualities in the field of plaintiff legal work. This is the picture I think that most people have of what a plaintiff lawyer does, going off into trial, arguing, presenting, speaking to the jury, and this is what it is more like. It is basically a lot of research. Most of my time is spent knee-deep in documents, or if I'm lucky, talking to and interviewing certain experts who might have information to help my case. I broke into the field of mass tort law dealing with these fellows, the big tobacco companies, and specifically working for the U.S. Department of Justice in the U.S. versus Philip Morris tobacco case. And as someone starting off in the area, it was really fortunate and lucky because I went into it having very little knowledge about cigarettes, other than the fact that they were bad. And I went in thinking, well, this will be an interesting job with the Department of Justice. And as I rolled up my sleeves and looked more into it and learned more about it, I realized just how little I knew and how much there was to learn. Among the things I learned is that cigarettes aren't just tobacco rolled in some paper. It is an extremely engineered product. So much so that if you take a close look at your cigarettes and even look at those little dots, the little holes, which go right next to the filter. They are specifically engineered in every cigarette to give you just a certain amount of nicotine and tar. Light cigarettes, as I'll get to a little bit later, are also complete misnomers. There's nothing very light about light cigarettes. And as perhaps many of you know, cigarettes are responsible for the deaths, even today, of 400,000 people a year. And the story as it affects me sort of doesn't begin until about the 1950s. But in the early 20th century, there really wasn't a great deal of knowledge that cigarettes were bad for you. And the various advertisements that you see, winning the World Series, smoking cigarettes can help you, and even touting that there were scientific benefits to smoking. But by sometime in about the 1930s, scientists started to get the picture that there might be something bad about cigarettes and finding links to lung cancer. In 1953, the tobacco companies themselves realized that they might have a problem with selling a product that more and more people believed was harmful to their health. And so they met at the Plaza Hotel in New York. Every major CEO and the PR firm of Hill and Knowlton joined them, and they got together to decide what should we do about this problem that people seem to think we're selling something which is bad for them. And they talked about it for a while, went away, came back 10 days later on Christmas Eve, in fact, and came up with a plan. Anybody have a vague guess at what that plan might have consisted of? That was sort of what they decided they wanted to do, because they only control one side of the equation. They can't control what some doctors are saying, what various research was showing. But what they decided to do instead was to offer the nation what they called a frank statement to cigarette smokers. And what they did is they ran this ad in 400 newspapers in the United States at that time. And in it, they said that they are going to put together a team of independent scientists to work as hard as they can and as honestly as they can to get to the bottom of this question of whether or not these cigarettes are actually bad for you. And inevitably what happened, of course, is it was the opposite. They set up a team of scientists which were under a supposedly independent label and whose sole job was to come out with information to tell the world and its consumers, don't worry about cigarettes, they're fine. And they came up with a tobacco playbook, which consists of declaring that it is an open question as to whether or not tobacco actually is harmful to people. The idea being that, well, some people say one thing, some people say something else. You can find scientists on either side. Meanwhile, they fund that contrary research and do as much PR as they can to get their point of view across while pretending it's not their point of view. Number 3, suppress and destroy damaging research. 4, intimidate. And 5, try to reassure. Moving first to the notion of the open question. These fine white gentlemen here that you see were the 7 upstanding CEOs of the tobacco companies in 1994 when they all went forth in front of the U.S. Congress and swore up and down, in 1994, mind you, that they really didn't know if cigarettes hurt people. People say things that it are. They say it's not. Some people say it's addictive. Some people say it isn't. Basically, from that 1953 meeting, those tobacco companies until 2000 generally maintained that smoking did not cause lung cancer or any other problems. This is despite the fact that their internal research told them from 1953 and before that cigarettes did cause cancer. And this is sort of what I'm getting at when I talk about the notion of when is a fact a fact. We see this sort of thing happen where you have scientists coming forward and saying that there's a problem here. And then you have the interested parties, in this case the tobacco companies, saying nothing to see here, let's just move right along. Until we know more, we can't actually come up with an answer. So the open question strategy is about just that, always saying that regardless of what information is coming from certain scientists, there are other ones out there who have a different point of view, and therefore we just need more time and more research before we can get to an answer. That is not the case, and as an internal memo from Brown and Williamson Tobacco Company, which was unearthed during the course of litigation, told us, doubt is our product since it is the best means of competing with the body of fact. So in 1999, the U.S. Department of Justice, directed by then President Bill Clinton, said, we have enough evidence, we are going to sue the leading tobacco companies for this conspiracy, an actual racketeering case, which goes back to that 1953 meeting in the Plaza Hotel in New York. I was fortunate enough in January in 2002 to be hired to work on this litigation. And it was eye-opening in every way. We had a team ultimately of about 30 lawyers working on it, which was gigantic. It was a huge team to be working on such a case. During the course of litigation, 400 lawyers made appearances for the other side, which if you know anything about how large law firms work, that means if 400 lawyers are appearing on the record, that probably means closer to 4,000 or more were working on it. And there was thoughts that as much as $1 billion a year was going out to Washington, D.C. lawyers in order to defend these tobacco companies. And what it goes to is that starting in 1953, there was this coordinated campaign by the different tobacco companies working together to keep the fiction going for as long as possible that we simply don't know whether or not tobaccos cause cancer. And in the meantime, saying we need to just keep looking and figure out what it is that seems to be causing this lung cancer in people who smoke. It sort of was like O.J. searching for the real killer. In 1964, the Surgeon General came out with a now famous report which put to bed any notion that tobacco might not be causing lung cancer. And that should have been the end of things. Surgeon General Luther Terry, working with hundreds literally of scientists, came up with this report. The response from Philip Morris at the time was, and all the others, was that it was quite preposterous to say that we know whether or not smoking causes cancer. And in the course of our litigation, one thing that's great about litigation, looking back at that image before of everyone researching rather than just being in front of the court, you get access to lots and lots of documents if you're doing litigation right. During the course of the DOJ litigation against Philip Morris, we received literally 4 billion pages of documents. We had no ability whatsoever to go through 4 billion pages. So what you do is you end up scanning and doing word searches on the percentage of the documents that you think you might have a chance to find something in. It's beyond looking for a needle in the haystack. But when you do find those needles, it's really great. And the best is when you find basically the defendant saying that, yes, we were lying all along. And those are the type of documents that we found. Meanwhile, at the same time as they're internally saying that we know this is true, they come out acting with great righteous indignation with such press releases as it is insulting to the scientific community, and another example of press conference science and an absolute masterpiece of bureaucratic obfuscation whenever any report came out suggesting that smoking and cancer were related. Part 2 of the strategy is to fund contrary research. And for example, there was a report which was released in 1984, which was titled The Cigarette Controversy, Why More Research is Needed. And in that report, in 1984, they cited 39 scientists who argued that there was not yet an established link between cigarette smoking and lung cancer. What was not disclosed at that time and was found out later is that those 39 scientists were all paid by the tobacco companies. Surprise. My primary role in the litigation that we did at the Department of Justice was working on finding the suppression and destruction of research that was damaging to the tobacco companies. And I was very fortunate that a lot of the wrongdoing was uncovered outside of the United States before it was uncovered in the United States. And as a result, I had the pleasure of traveling many times to both Australia and the United Kingdom to try to track down documents. There were several different ways that the tobacco companies tried to keep documents and information out of the public eye. One of them in of itself was in working on litigation. As I said, when they produced 4 billion documents, it's nearly impossible to find anything. What they did do, even in the litigation with the documents, which generally were the most useful, is they claimed that those documents were protected by legal professional privilege. What they did is send a document not only to between the CEO and the CFO, but send it to a lawyer as well, and then claim, well, because a lawyer saw it, it is legally privileged and we can't give it to you. And I don't know how many of you know this, but that's not how legal professional privilege works. And so we had to fight them tooth and nail trying to get them to even produce the documents that were good that they were supposed to produce to us. At the same time, they were taking various documents, and if there was litigation going on, for instance, in the United States, they would take the documents and send them to London or to Sydney, and then say, well, we can't produce these documents for you because they're not in our possession, custody, or control, because they're now outside of the United States. This, again, not allowed. We were having a very difficult time trying to trace this mess until we caught a break. And we were contacted by a former lawyer for the tobacco companies named Fred Golson. He actually contacted a lawyer who I befriended named Peter Gordon in Australia and said, yeah, this litigation that's being worked on where they're saying that the tobacco companies were trying to keep documents out of the hands of the public, yeah, that was precisely what our strategy was. And they had what was called a document retention policy. And what the document retention policy said was destroy documents which might be bad for us. And what Mr. Golson was able to tell us and ultimately testified to in the U.S. courts in Washington was that anytime they had documents that they didn't want to get out to the public or get out to the various lawyers who were suing them, they would put them into the shredder and say, well, we just have so many documents that we need to get rid of a few. Again, this is not okay. Meanwhile, the lawyers were involved in all the tobacco companies' work from top to bottom, including holding sessions with the scientists at the tobacco companies, telling them what not to ever put in writing, including such terms as the word addictive. Well, the relevant terms they wanted to keep out were the terms addictive, disease, and cancer, words that would seem to be somewhat relevant if you were a scientist trying to do research into tobacco. As discussed before, another tactic that was used by the tobacco companies was intimidation. And I don't know if any of you have seen the movie The Insider with Russell Crowe. And Russell Crowe plays Jeffrey Wigand, who is a Brown and Williamson Tobacco Company research scientist who was so disgusted by what he saw within the internal research that he decided he would go public and share this research, and was subjected to all kinds of intimidation from the tobacco companies, threats to his family, lawsuits, blackballing within the scientific community. And in the film, there's a scene where he opens his mailbox one morning, and there is a bullet sitting in the mailbox. And during the course of preparing our case, I had the pleasure of traveling up to Michigan and going to Mr. Dr. Wigand's house and sitting down and meeting with him. And as we're talking about all the important stuff for the case itself, finally I just had to ask, is it really true? Is there really a bullet in the mailbox, or is that really just a bit of cinematic license? And he's like, oh no, I woke up in the morning and I was because there was a bullet in my mailbox. So what I would be showing you now is a photograph of Russell Crowe and a photograph of Dr. Wigand. And without any disrespect to Jeff, I don't think they look all that much alike, shall we say. After intimidation, one of the final steps in the campaign of the tobacco companies was reassurance. And so once more and more people started to have some suspicion that smoking cigarettes might just be bad for them, they decided that, well, we could put on the market low-tar or light cigarettes, and that these low-tar cigarettes will tell people, look, you can keep smoking and do it in a way that's healthier for you. So low-tar became a very popular strategy for the tobacco companies, trying to say to people, well, you can have your cake and eat it too. Even if you think that cigarettes might be a little bit bad for you, we have these low-tar cigarettes. The problem with that is that internally, they already knew that the low-tar cigarettes not only were no better for you, but in fact, because people who are addicted to cigarettes smoke to get a certain amount of nicotine and tar, they actually were getting more tar under a light cigarette because they were puffing more vigorously than they would under a regular cigarette. Another way that they would try to reassure people is once it became clear that cigarettes were in fact bad for people, the next sort of battleground was secondhand smoke. The fact that people who didn't make the choice to smoke might suffer some of the consequences just by being in close proximity. And so one thing that tobacco companies did early on was go from the terminology of secondhand smoke to the far less concerning terminology of environmental tobacco smoke. And it is the kind of thing where literally if you look at documents that are put out by the tobacco companies and in fact picked up by many newspapers, it refers to ETS or environmental tobacco smoke instead of secondhand smoke. We went through, as I said, the litigation started in 1999, and the case finally went to trial in 2006. It resulted in a 1,700-page decision from the trial judge, and it went through and closely documented and found in our favor the various lies that had been perpetrated by the tobacco industry over time. And again, what it always was about was arguing that there remains an open question about saying that we just can't be sure yet. Let's not close the book on this. Let's keep doing research. Once we find out if there's a real problem, we'll share it with you. What's interesting is that this became a playbook, not just for the tobacco companies, but for virtually anyone else who was purveying a product which the public started to get a sneaking suspicion it might be bad for you. So acid rain went into the same sort of thing. Chlorofluorocarbons went into the same sort of thing. In a slightly different realm, you have the pharmaceutical companies who dealt with things from a slightly different sphere. And I'm not sure quite if we have enough time to get too deeply into this, but during my time working in Australia, I worked on a couple different cases. One of them was the Vioxx case, which I don't know if any of you have heard of the drug, but it was a painkiller, which it turned out, depending on the science, somewhere between doubled or quintupled your risk of having a heart attack. And this was information which was available to the company at a relatively early time period, which they buried or justified and kept the drug on the market for another 4.5 years, during which time they made an additional $14 billion. The other case I worked on over there was the case of thalidomide. Thalidomide was a drug around 1960 that was on the market. And some of you may have seen people affected by it because the sort of quintessential victim of thalidomide is somebody who, while they were in their mother's belly, their mother took the drug, and then they were born with horrific birth defects. No arms in some cases, or tiny little flipper arms and legs, really horrific birth defects. And even though that connection was finally made after the German company which had produced the drug, which perhaps not coincidentally, the leading scientist who was working with that company was a former Nazi German doctor in concentration camps. They put this drug on the market despite the fact that they had advance warning that it might cause birth defects. Looking at pharmaceutical products is different than looking at tobacco because it's a different risk evaluation. Most drugs which are on the market do at least some good, and it's difficult to look at and evaluate what is the good compared to what is the bad. But what's frustrating is that because there's so much money involved, just like with tobacco, it becomes very, very difficult to get at the truth, because there are many different ways to manipulate drug trials. What? Yes, it's the Food and Drug Administration. Great question. The Food and Drug Administration approves the medicines. And what do you think the Food and Drug Administration does in order to approve medications? Excellent, great. Clinical studies. And the idea is that you do have to do clinical studies, randomized controlled clinical trials. You take one group of people, give them a placebo or a different drug, give another group of people the drug which is being tested. However, one might think that A, this was done by the federal government, by the Food and Drug Administration themselves, which it is not. It is done by scientists who are funded by the drug which they're seeking to approve, the company which has the drug seeking to be approved. In addition, I always thought, until I started working on these sort of cases, that one of the important things to test for a drug is the drug safe? Turns out that's really not what you need to do to get a drug approved by the Food and Drug Administration. What you need to do is show that it's efficacious. You need to be able to show that the drug has some positive impact. And if in the course of looking at whether the drug has a positive impact, you find something which might lead you to believe that it poses a safety risk, then you have to start doing some of those tests. Absolutely. It's off-label marketing. So once a drug is approved for a certain purpose, you then decide, well, we can make a bunch more money selling the drug for an entirely different purpose. And it's a little tricky what the legality of it is, but it's done a huge amount where you start advertising for the drug, ask your doctor about Vioxx for dental pain instead of just for osteoarthritis that it's approved for or something like that. And that is a huge way to kind of get around it. But it's the kind of thing where, generally speaking, with all of these type of things, if you're looking at a question and trying to figure out, as the title of this is, what is a fact? Is it really a fact here? Is following the money is usually pretty good advice. And in almost every situation, you're going to have a huge amount of money arrayed on one side in order the people who are looking to make money off the product, and a relatively small amount on the other side, more independent people trying to figure out whether or not there's a real harm to be concerned about here. In addition to the fact that these randomized clinical trials can be impacted depending on the way you structure the trial, is the fact that an enormous amount of money is given to doctors either to work on a product, to be taken away on sort of retreats, to be taught about the product, taken out for dinners. And most doctors are so busy that they don't have the time to do their own independent research into most of these issues. And so a lot of them do end up relying on the pharmaceutical companies themselves to get their information. Going back to the plaintiff lawyer side of things, a lot of people approached me and said, isn't it crazy that the people who were found to have had heart attacks or strokes that were caused by Vioxx received so much money? $4.8 billion was the amount of the verdict against Merck Corporation in the Vioxx case. This is in the U.S. version of the case, which, if you dig it a little deeper, amounted to, on average, about $50,000 for each person who suffered a heart attack. More importantly, almost, in my point of view, is the fact that the drug was left on the market for 4.5 years after there was strong evidence that the drug was causing increased heart attacks. In that time, as I said, they made an extra $13 or $14 billion. My concern is that the next time you have another company which finds out internally that their drug is causing heart attacks, causing birth defects, causing whatever it is, they still end up leaving the drug on the market until they get caught, because the economic equation tells them we can still make an extra $10 billion. And if we get caught at the end, we'll pay out, we'll still be ahead of the game. This is not meant to be an indictment. Sorry. It's a good question. It very much depends. This is where the Food and Drug Administration gets involved. The idea is that for certain types of side effects, they're deemed too dangerous to leave the drug on the market, and oftentimes there's a bit of a weighing between what is the benefit. If there's a new cancer drug which is coming on the market, and there are some pretty extreme bad side effects, that drug will still probably go through, because the idea of being able to cure cancer is great. If you were to have a drug which made hangnails less painful, we would not tolerate the same risk because it just isn't that big a deal what the drug is doing on the positive side of it. Some drugs will get what's called a black box warning put on them, which is a very stringent warning on the front of it saying this is a problem. What drug companies and the FDA have done, which is somewhat problematic at times, is they will list in the paperwork that comes with the drug about 100 potential side effects. And so it gets drowned out so much because some of the side effects are something that's happened to one person. They'll just throw it in there. And so every drug has these, and you need to have a better way to communicate. I like to think that there has been better progress on the listing and revealing of the side effects. The issue there relates to the question asked previously, though, is that if the side effects are going to be significant enough, the FDA might step in and say you can no longer sell the drug. And so there still is a fear among companies, particularly about certain products, that if they disclose everything, particularly at the earliest stages before there's approval, it might torpedo the entire drug. And I am sympathetic to pharmaceutical companies from the perspective that they put a lot of money into developing drugs. And it must be pretty painful for them if they've put millions of dollars into a drug and then it comes back that they can't put the drug on the market. But at the same time, at the end of the day, if there's going to be a risk that eventuates, I'd rather it be economic harm to a company than physical harm to a human. Because I was just nodding. Okay, sorry. All right, so moving along from big pharma to global warming. In the early 1960s, 45% of Americans believed that cigarettes cause cancer. That was during the period of time just before the 1964 Surgeon General's report came out, which increased significantly the number of Americans who believed that cigarettes cause cancer. That is 45%, the same number of Americans who believe in man-made climate change today in 2015. And what's happened is you've had the reason that, despite the fact that, again, on the science, there aren't a lot of questions really that are there among people who are climatologists or who deal in examining climate change. The issue is more or less settled. But what's being done this time, it's not the cigarette companies, it's the fossil fuel companies, the oil companies, and in some cases the automobile companies, who have vested interests in being able to continue business as usual. And so what we've seen is, once again, open question, fund contrary research, suppress or destroy damaging research, intimidate, reassure. In 2010, a book came out called Merchants of Doubt by Naomi Oreskes and Eric Conway. And what the book pointed out is that not only are the fossil fuel companies today using the same strategies to try to maintain that there is still an open question about global warming and that we don't really know the answer as to whether or not man-made burning of carbon is causing global warming, but literally a lot of the same players are involved. Hill and Knowlton, who were there at the Plaza Hotel in 1953 helping the tobacco companies, are today working with fossil fuel companies on developing strategies to maintain the open question. You have pictured here Frederick Seitz and Fred Singer, who are both scientists who worked on behalf of the tobacco companies during the time when the tobacco wars were going on, that today are working on, or today I believe that Mr. Seitz has passed away, but who in recent years have worked with fossil fuel companies to try to maintain the fiction that we don't know whether or not humans are contributing to global warming. It's a very good question why they aren't. And part of it is that you have so much money and pressure on the one side pushing a certain viewpoint. Generally speaking, a lot of the scientists who end up going on are less likely to be in academia, because in academia you are more likely to be held accountable to some degree. But if you're working for think tanks and things like that, which are funded by these companies, there are less ways to hold people accountable. And part of the problem we have today is we're so bombarded by information that very few of us have the time to go through and look at, well, what are Fred Singer's qualifications here? And even to learn the fact that he had previously worked on tobacco. But it's a pretty good question. And so you literally have some of the same scientists, some of the same PR firms, many of the same law firms who are working to fight concluding that it is a fact that human beings are contributing to global warming. This year, this time I've got the 2016 right, a study has come out by Cook called Consensus on Consensus. And it looked at various studies trying to figure out, is there scientific agreement on global warming? And each of these studies came up with numbers within the same general area, saying that somewhere between 90 and 100% of scientists working in the field agree that humans are causing global warming. The reason why there is some degree of differential is sometimes the language used can be slightly different, but broadly speaking, there is full agreement here. In addition, the scientists who have greater expertise in climate science tend to be the ones who agree more and more that global warming is caused, A, is happening, and B, is caused by man's activities. And so it tends to be that the ones who are in disagreement are the ones who have come over from another field and have realized that they can make a lot of money by publishing in this field if they take payments from the fossil fuel companies and others. So again, this is all, again, maintaining this open question. The same thing that we saw from the tobacco companies 60 years ago. Funding contrary research. There's the George C. Marshall. There was the George C. Marshall Institute, which was founded by the gentleman we looked at previously, Frederick Seitz. And they've said such things as arguing that cyclical variations in the intensity of the sun would offset any climate change associated with elevated greenhouse gases. This gentleman is Wee Hock Soon, who, if you are a devotee of watching C-SPAN, you will see this man quoted a great deal. Whenever someone gets on the Senate floor or the House floor and wants to argue that global warming is not real or is not caused by man, they will cite research from Dr. Hock Soon. Excuse me, I'm not even sure if he is a doctor, because it turns out that he has a degree in aerospace engineering and no formal training or study in climatology. It gets better that in his various publications, he somehow forgot to disclose that he has received payments of $1.2 million in total from fossil fuel companies in the course of his research in the area. So it's that both spending the money there and then not even disclosing to the public what's going on. And once more, we have efforts to suppress or destroy damaging research. The Global Climate Coalition was a group of scientists brought together by the fossil fuel companies. And even their own internal reports said things like the scientific basis for the greenhouse effect and the potential impact of human emissions of greenhouse gases such as CO2 on climate is well established and cannot be denied. This was in 1995. Scientists paid by or sympathetic to the fossil fuel industries, and 21 years ago, there was no question about it. And yet we still sit here debating whether or not global warming is a fact. Meanwhile, even earlier, Exxon scientists in 1977 and 1978 internally concluded that there was general scientific agreement that fossil fuels were influencing climate change. And in the 1980s, the director of Exxon's Theoretical and Mathematical Sciences Laboratory had already concluded that the effects of global warming may be catastrophic after 2030. At the time, that was 50 years away. Today, that's 15 or less years away. And that's all time that we've wasted where we could have been making progress trying to figure out what to do about something which is a fact. The other tactic is intimidate. Recently, you've seen action being taken by various states attorneys general to bring lawsuits against Exxon now that it has come out that there are all sorts of internal documents showing that they knew that the earth was warming and that it was being caused by their products. In response, Exxon has started suing the state attorneys general and suing, in this instance of this headline here, the Union of Concerned Scientists, a nonprofit organization that's been providing scientific support and information to a lot of the state attorneys general. Reassurance remains part of it today for discussions of global warming. Secondhand smoke is to environmental tobacco smoke as global warming is to climate change. We use the word climate change now where we used to use the word global warming. Part of the reason can be seen in a 2002 memo from Republican pollster Frank Luntz to President George W. Bush's staff, saying it's time to start talking about climate change instead of global warming. Climate change is less frightening than global warming, and while global warming has catastrophic connotations attached to it, climate change suggests a more controllable and less emotional challenge. So basically what we're seeing is again and again history repeating itself with real big scientific questions that face us, that affect us. And you end up having scientific consensus reached at a certain point in time, but then you have those who stand to lose from that scientific conclusion working very, very hard to maintain the fiction that what is a fact is not a fact. And I suspect we're going to continue to see it more and more because it's really complicated. I don't know that any of us in this room have done any research on climatology, done sort of controlled trials in some sort of pharmaceutical. And the way it is reported by the news is going to be very influential and impactful to us. And the way that it's being reported largely nowadays, as it was many years ago with tobacco smoke, is that there are some scientists who say, for example, that global warming is happening, and there are some scientists who say that it isn't. And what we don't get down to is the fact that the vast, vast majority of scientists hold one opinion, and moreover, that the scientists who A, aren't being paid, and B, who have more expertise, are all more or less lined up on one side. Well, I've been talking a lot. Are there any questions that y'all have about any of what's been discussed so far? I would answer that question by saying when there is consensus among most leading scientists in a field, then it's a fact. And in each of the cases that I've referenced, that's been the case. Generally speaking, when you read something, you want to know what the source is. And it's the whole thing when someone tells you, like, you know, my cousin's friend heard, you're going to take that differently than reading it in the New York Times. And sometimes it can be difficult to actually track down what the real source of information is. Like, we didn't know until recently that a lot of these studies were being funded by the sugar industry, and that the reason that we were so focused on fat over sugar was in part because it was this big push by the sugar industry. So now we have to kind of take a step back and decipher, well, what's what? The fact that the sugar industry funds something doesn't mean that all the research they produce is wrong. Meanwhile, the fact that they're trying to say that fat is bad for you doesn't mean that fat's good for you. But we need to get back to some baseline of trying to look at, well, where is the real research and what are the comparative risks? And that's what so much of this is about, is comparative risk. As we all know, you see the 100-year-old little lady who is on the Today Show or something who says, I've smoked all my life and I'm still here. That happens. It's with all these things, it's a matter of risk. And so it really becomes a matter of properly evaluating and understanding what those risks are. It's incredibly difficult to figure things out like that today, and it's aiming, as someone who often is in the field of research looking at these things, it becomes very difficult to know. And even with pharmaceutical products, doctors who specialize in a field, if you look even at peer-reviewed articles, oftentimes there's information built into those peer-reviewed articles that you don't know. With the Vioxx case that I worked on, there were a handful of participants in the randomly controlled trials that were excluded, which weren't written about in the article. And it turned out that they were people who had been on the drug Vioxx, who'd had heart attacks. And some reason was given as to why we don't need to count those. And then it wasn't even explained. So even a scientist looking at a peer-reviewed article in the Journal of American Medicine, or whatever it is, still might not have known. So it is really incredibly difficult to get there in certain cases. In other cases, it's pretty easy. I mean, with tobacco smoke, we've had consensus for decades and decades. With global warming, we've had consensus for decades. With other things, it gets trickier. You have, for instance, the anti-vaxxers, the people who believe you shouldn't vaccinate your children. It's connected with autism, whatever else. As far as I know, I haven't looked deeply into it, but I don't know that there is a sort of evil corporate hand behind it manipulating it. But at the same time, there is this misinformation out there pointing to studies which simply go against the vast majority of scientific consensus on the issue. My background is as a lawyer, as a plaintiff lawyer. And I'll now sort of go with the last little bit here. It's not so much me, more so looking at plaintiff lawyers in general, remembering that while some of them are scumbags, a lot of them aren't and are doing really good work. And what we saw with both tobacco and what we're seeing with global warming is that democracy isn't always the best for communicating and making decisions on dealing with certain scientific issues. And so basically Congress didn't take serious action on tobacco for decades. They haven't taken serious action on climate change. And in the first case, it took litigation to finally get the admissions necessary to then go forward. And it may prove to be the same way here, that Exxon has already stated now that they do finally accept that global warming is real. And I would put forth that it's probably unlikely that they would have gotten there if documents hadn't come out showing internally they'd already been saying the same thing for decades. But that's my background is as a plaintiff lawyer. I went to work for the Department of Justice after I was out of law school for a few years. Worked on the tobacco litigation there, literally just one case. I believe this is called preaching to the choir.
What's your advice then, I guess?
Well,
just knowing that the information
no, there's lots of different steps here because it is a big, invidious problem. And I mean, part of it here is obviously the Superman plaintiff lawyer thing is a bit over the top, but the idea is that plaintiff lawyers are considered these evil beasts who are sucking the lifeblood out of American commerce and industry. And my point is that a big part of what they're doing is actually revealing what's really going on. And what you've had happen here in the States, when I was in Australia, was going on, is you have what's called tort reform. And you have politicians getting up there and saying, we need to stop these lawyers making so much money, suing McDonald's over a spilled coffee. And you pick out, and granted, there are always some ridiculous cases out there. But what is being shown are the ridiculous cases rather than the others. And what's being done more and more is getting it set up so that it is not economic to actually proceed with a lot of these cases. And specifically, I've worked on what are called class actions or mass tort cases, which are where literally if something happened to an individual person, it would not be economically viable other than as a nonprofit to take the case to court. But if you can pull a bunch of people together, then you can start to have enough resources that you can actually make the case. And so one thing, again, so much of it just goes back to democracy, is basically trying to do all we can as individuals to hold people accountable. I worked as well on the Senate Judiciary Committee for a Democrat, full disclosure. And one thing you'd see is, certain, mostly, not exclusive, but mostly Republican lawmakers on climate change get up there. And I mean, literally one of them, James Inhofe, who is now the head of the Environmental Committee in the Senate, came onto the Senate floor once with a snowball and said, "See, where's global warming?" I mean, it was maybe an effective ploy. It doesn't make a lot of sense. But it is hard. I think the biggest things to do are sort of individually for yourself. And if we all collectively were to pay more attention to certain things, if less cigarettes get sold, if we actually pay attention to things like miles per gallon on our cars, it starts to make an impact, and corporations pay attention when people vote with their pocketbooks. Well, a law like that, which is one that I'm not aware of, it's the kind of thing, so many of the laws that get passed get pushed into, I don't know if that's a state law or federal law. I assume that'd probably be a state law. But it may be that there's a genuine safety issue that caused it. It may be that there's a special interest that caused it. It's really hard to know in these situations. And the problem you often have is there's a lot of incentive to do research to show, for example, that a drug does something good, and so we have to get it out there on the market. Where is the incentive to do the research into what chemicals are in the mattress? I don't know who has, maybe someone's done that research. Well, there are antitrust issues that can occur when a company gets too big a share of the market. Sometimes you can have antitrust issues when there's what's called vertical integration, when you're putting together the company that both produces and distributes something. In terms of just pure company size, we really don't have anything that addresses that. To me, the issue is that you need to make sure that, so to speak, the punishment fits the crime. And you need to make sure that when a company gets caught red-handed, they end up paying enough that it makes them think twice or three times about doing something the next time. And that's the issue with what I don't see. I don't know. I think in that article that I said, it talks about how when the decision came down holding the companies accountable, their share price went up. Because they make so much money that as long as in certain cases they're not being more or less shut down or their business is being interfered with in a gargantuan way, just the mere certainty that they can keep doing business is a good thing. And I read something the other day that Philip Morris basically is, if you put your stock in Philip Morris in like 1915 or something, you would have done better than putting your stock in anything else, despite the fact that over the last 60 years we know cigarettes cause cancer. And then it was broken down further to say that even over the last 20 or 30 years, when it's become less and less of a truly controversial question, share price still keeps going up. Because even while you've had some degree of decline in American smoking, A, there's been a corresponding increase in the price of cigarettes, and B, they sell it all over the world. And while you've had progress in a lot of the industrialized world, much less so in the third world. And the United States even has taken, I'd say, some pretty ugly actions in which we've threatened sort of trade sanctions and stuff against certain third world countries when they've tried to do things to increasingly limit tobacco imports or tax tobacco imports. Because while we've been at this point concerned about cancer in the U.S., we don't seem to particularly care if it's, as long as we're selling more goods overseas.